Okay, we're going to read this Pennsylvania Supreme Court case live because Pennsylvania is bold, pure gold. Ferris versus Glen Alden Court, 1958. Justice Cohen gave the opinion. We are required to determine on this appeal whether, as a result of reorganization agreement executed by the officers of the Glen Alden Corporation and List Industries Incorporation and approved by the shareholders of the former company, the rights and remedies of a dissenting shareholder accrue to the person. Glen Alden is a Pennsylvania corporation engaged principally in the mining of anthracite coal and lately in the manufacture of air conditioning units and firefighting equipment. In recent years, the company's operating revenue has declined substantially, and in fact, its coal operations have resulted in tax loss carryovers of approximately $14 million. In October of 1957, List, a Delaware holding company owning interest in motion picture theaters, textile companies, and real estate, and to a lesser extent in oil and gas operations, warehouses, and aluminum piston manufacturing, purchased through a wholly owned subsidiary 38.5% of Glen Alden's outstanding stock. This acquisition enabled List to place 3 of its directors on the board. On March 20th of 1958, the two corporations entered into a reorganization agreement subject to stockholder approval, which contemplated the following actions. 1. Glen Alden is to acquire all the assets of List. Accepting a small amount of cash reserved for the payment of List expenses in connection with the transaction. These assets include over $8 million in cash held chiefly in the treasuries of List wholly owned subsidiaries. In consideration of the transfer, Glen Alden is to issue 3,621,703 shares of stock to List. List in turn is to distribute the stock to its shareholders at a ratio of 5 shares of Glen Alden stock for each 6 shares of List stock. In order to accomplish the necessary distribution, Glen Alden is to increase the authorized number of its shares of capital stock from 2.5 million shares to 7.5 million shares without according preemptive rights to the present shareholders upon the issuance of any such shares. Further, third, Glen Alden is to assume all of List's liabilities, including a $5 million note incurred by List in order to purchase Glen Alden stock in 1957, outstanding stock options, incentive stock options plans, and pension obligations. Fourth, Glen Alden is to change its corporate name from Glen Alden Corp to List Alden Corp. Fifth, the present directors of both corporations are to become directors of List Alden. And sixth, List is to be dissolved, and List Alden is to then carry on the operations of both former corporations. So this is a consolidation. In other words, 2 days after the agreement was executed, notice of the annual meeting of Glen Alden to be held on April 11th of 1958 was mailed to the shareholders together with a proxy statement analyzing the reorganization agreement and recommending its approval, as well as approval of certain amendments to Glen Alden's articles of incorporation and bylaws necessary to implement the agreement. At this meeting, the holders of the majority of outstanding shares, not including those owned by List, voted in favor of a resolution approving the reorganization agreement. On the day of the shareholders' meeting, plaintiff, a shareholder of Glen Alden, filed a complaint in equity against the corporation and its officers, seeking to enjoin them temporarily until final hearing and perpetually thereafter from carrying on and executing agreement. So that's the plaintiff party who's seeking to join them in fulfilling, carrying this out. But all the shareholders voted in favor, or whatever the percentage of them necessary to vote in favor. And the gravamen of the complaint was the notice of the annual shareholders meeting did not conform to the requirements of the Business Corporation Law. 15, Pennsylvania statute, Title 15 of Pennsylvania statute, section 2052-1, and sequential in 3 respects. 1, legal notice. So, in the first respect, it did not give notice of the shareholders that the true intent and purpose of the meeting was to effect a merger or consolidation of Glen Alden and List. 2, it failed to give notice to the shareholders of their right to dissent to the plan of merger and consolidation and claim fair value for their shares. And 3rd, it did not contain copies of the text of certain sections of the Business Corporation as required. Law as required. So, by reason of these omissions, plaintiff contended that the approval of the reorganization agreement by the shareholders at the annual meeting was invalid, and unless the carrying out of the plan were enjoined to suffer irreparable loss by being substantial property rights. So that's the causal connection to loss. The defendants answered admitting the material allegations of fact in the complaint, but denying that they gave rise to a cause of action because the transaction complained of was a purchase of corporate assets. As to which shareholders had no right to send or increase. For these reasons, the defendants then moved for judgment on pleadings. That's their answer. Now, the court below concluded that the reorganization agreement entered into by the two corporations was a plan for a de facto merger, and that therefore failure notice of the annual meeting to conform to certain requirements of the merger provisions of the business corporation law right now. The notice effective and all proceedings in furtherance of the agreement void. And I thought it was consolidation, and here the lower court thought it was a de facto merger. So this is a holding the trial court level. Where for the court entered a final decree denying defendant's motion for judgment on normal proceedings and judgment upon plaintiff's complaint and granting injunctive relief. All this appeal followed when use of the form of business organization first became widespread. It was relatively easy for courts to define a merger or sale of assets until the label of particular transactions or the other chemical fluctuation secondary law and list estate as citation color for St. Mary's Brewing Company. Citation. But promptly by the desire to avoid the impact of adverse and to obtain the benefits of favorable government regulations, particularly federal tax laws, new accounting and legal techniques were developed by lawyers and accountants, which interwove the elements characteristic of each by creating higher forms of corporate amalgamation. Thus, it is no longer helpful to consider an individual transaction in the abstract and solely by reference to the various elements therein determine whether it is a merger or a sale. Instead, to determine properly the nature of a corporate transaction must refer not only to all of provisions, but also to the consequences of transactions, the purposes of provisions of corporation law that shall section 908. So part A of the Pennsylvania Business Corporate Law provides if any shareholder of a domestic corporation which becomes a party to a plan merger consolidation shall object to such plan of merger consolidation, such shareholder shall be entitled to the fair value of his shares upon surrender of the shares certificate or certificates representing shares. And that's from May of 1933 as amended. This provision had its origin in the early decision of this court in Lawman versus Lebanon Valley.